Late last week, the Assembly of State Parties of the International Criminal Court voted by a margin of 82 to 13 with 15 abstentions to remove the prosecutor of the International Court, Karim Khan, effective immediately. And Khan was removed for sexual misconduct against a junior staff member. His lawyers have pledged to challenge the outcome. That will be the focus of our discussion today, the removal and what comes next for the International Criminal Court. I'm Ryan Goodman, co-editor-in-chief at Just Security. And as our guests today, Professors Rebecca Hamilton and Alex Whiting wrote an essay in Just Security following the decision of the Assembly of State Parties. And I'll just quote it at the outset, quote, "The vote by the states to remove Mr. Khan was decisive and based on an extensive and lengthy investigation. That said, the episode has exposed deep problems with the court's internal governance structure and fractured its various constituencies, all amid the most challenging period in the court's existence. If the court is going to fulfill its mission of justice for victims and survivors of the gravest crimes, much hard work lies ahead." So then, some of the questions that I think will frame our discussion are, what does the episode mean for how sexual misconduct allegations are investigated by an international organization such as the International Criminal Court? Second, what fractures were created in the international legal community about how the investigation and removal were handled? And what comes next for the International Court and those who support its work and the next prosecutor? So Beck and Alex are foremost experts in this space, some of the clearest thinkers in any case, but especially in this space as well. It's really a privilege to be with you guys for this discussion. Would you mind just first introducing yourselves and saying a little bit about your own professional background and having worked at the court?
Sure. Thank you for hosting the conversation, Ryan. I'm a professor of law at American University, Washington College of Law. I worked in the immediate office of the prosecutor at the International Criminal Court from 2007 to 2009. I'm part of the Association of International Criminal Law Prosecutors, and I have stayed engaged with the court's work ever since.
It's great to be here with both of you. I'm Alex Whiting, and I have worked at I'm a professor of practice at Harvard Law School. At the moment, I've worked at a number of tribunals in The Hague. I was at the International Criminal Court from 2010 to 2013 as the investigation coordinator and then the prosecution coordinator.
Great. So I thought to start out by just level setting. First couple of questions to Beck and then to you, Alex. And to level set, first with Beck, kind of just laying the groundwork of what happened and in terms of the facts and how the Assembly of State Parties voted, and then to Alex to start laying out the procedure that preceded the vote by the Assembly of State Parties. So, Beck, can you just give us a bit of a summary of what were the factual allegations or the substantive case against Karim Khan as alleged by the complainant?
Yeah. So, I should start by saying none of us have seen the underlying investigative record. That remains confidential. But after the investigation was complete, I want to say just over a week ago, maybe 10 days ago, the complainant, her name is Sarah. She's asked the media not to use her full name. She spoke publicly about her experiences for the first time. She did an interview with Christiane Amanpour. For anyone that hasn't watched it, it is painful viewing, but I think it is important. What you see is a young woman who is very sincere and is also visibly traumatized as she recounts sexual harassment by Mr. Khan that was taking place for more than a year at the office in The Hague, as well as on official court missions overseas, escalating to non-consensual sexual conduct, including digital and genital penetration. And it's worth underscoring here that Mr. Khan was the chief prosecutor at the court. Sarah is a junior lawyer, his direct subordinate. And, we all come at this from our own positionality. I'm no different. But I do really want to take a moment at the top to highlight that as this whole conversation has played out in public over recent months, we've seen a huge amount of focus on what is and has been at stake for Mr. Khan, what is at stake for the court, All of that is appropriate, but it has not in any way been matched by considering what has been the situation for the complainant here. And there's been just a sort of striking lack of empathy or really disregard for what it would have been like as a young professional in the workplace to live in fear of retaliation by someone who has so much more power than you. So that is the context for the allegations as we in the public understand it at this point.
Thank you. And in fact, that's also why I wanted to have that be the first question to foreground that, because I think otherwise it has been exactly what you said, Beck, diminished or lost in large parts of the conversations. And I also highly recommend the very lengthy interview that she did with Christian Amanpour. I think it's about 45 minutes. It's very detailed, highly credible. I don't think anybody objectively could look at that interview and not walk away with that impression. So the second question I just wanted to also lead out with you, Beck, is you also wrote a piece for Just Security preceding the vote. You and Alex wrote a piece separately after the vote, but preceding the vote, your piece was about how the Assembly of State parties should frame the question that they had before them as to the decision as to whether or not to remove Mr. Khan. Can you just talk a little bit about how you actually think the Assembly of State parties did frame the question or decided the question that was presented to them? And just to lay out there a little bit more, what I mean by that is there are different ways of thinking about the decision. Is it, whether or not to punish a person, whether or not to think about the interests of the institution, what kind of proceeding is this? So can you just talk a little bit about how you see the whole matter having gone down on Friday?
And I think that question of what kind of proceeding even is this was really important to get clear on before the vote. And I, in that piece was coming back to what is the Rome Statute, which is sort of effectively the constitution of the court. What does it say? And it's very clear under Article 46 that removal comes down to a absolute majority vote of the Assembly of States parties. So that is all the states that have joined the ICC on a finding of serious misconduct by the prosecutor. What the Assembly of States parties is not is an appellate court that is reviewing procedure. It is not a criminal court. It is not making a criminal adjudication. And similarly, removal is not a criminal sanction. What it is, the best analogy that I could come up with, certainly for a US audience, is effectively an impeachment vote, right? It is a vote on the fitness for office. And one of the core mandates of this court is to investigate sexual and gender-based violence. The court is asking victims and survivors of these crimes at immense personal risk to come forward and provide their testimony. And in that context, with the majority of states finding that there had been serious misconduct by Mr. Khan, the removal vote, I think, needs to be understood simply as a judgment that he is not fit to lead this institution, given its mandate.
And then, Alex, I want to turn to you and then back to both of you. So there's like a multi-part question. So from some quarters, there were criticisms raised about the process of how the court went about investigating Mr. Khan and then assessing his conduct. And so first, Alex, to you, could you just briefly describe the 4-stage process, I think 3 or 4-stage process, as to how it all went through the International Court and the different bodies that looked at the case? And I think just even in the way that you describe it, for some listeners or folks watching this, they can better understand what each of those bodies were, what their responsibilities were, because there's a lot of misunderstandings being communicated, whether deliberately or not, about them. So just if you could just lay the groundwork for that in the different bodies that looked at the case along the way. And we'll be trying to avoid acronyms, one of them being the first body being the UN Office of Internal Oversight Services, or OIOS. And then second, this is the part of the multi-part question for both of you, maybe starting with you, Alex. I want to try to articulate what I think are the strongest criticisms so that people have them in their most charitable and strongest forms. So I think there are two main ones that I'm aware of, or in my estimation, are the two strongest criticisms or claims that were made. One criticism was that the International Criminal Court appointed a panel of eminent judges to review the OIOS's findings, and the panel unanimously concluded that the evidence did not support removal and was then, according to this criticism, a political decision by the next body, which was a Bureau of State Parties after the panel of judges, to reject the judges' conclusions. That's criticism number one, that these are the three-judge panel. They adjudicated it, decided the evidence wasn't sufficient, yet it all went forward. That's criticism one. And then criticism two is a due process claim that Mr. Khan was denied due process. If you're ever going to have any institution exact some kind of penalty against somebody, it should only be done after that individual has due process. And the strongest form of the criticism is, in a sense, that one of the strongest forms of the criticism, that he should have been provided the right, the ability to present his case, or his lawyers to present the case on Friday to the full assembly of state parties. So, Alex, can you just lay out what exactly those stages of the process were? And then if you can both jump in on addressing the criticisms that have been circulating.
Right. So I think it's important to dig into the procedure, not to get too much into the weeds on it, but to kind of get clear on what the procedure was, because and to echo what you both said about the complainant and her interview, the procedure ended up being the focus of much of the debate, and what it meant for the court and what it said about the court, and people read into it all kinds of things about the court. And what got lost, as you both said, was the victim and the complainant and the actual conduct. So I thought it was important for her to do that interview to kind of recenter that discussion and put the focus back on where it should be. But just to lay out the process. So when this all broke some 20 months ago, the ICC set up a process where a multi-stage process in order to conduct an investigation and look into these allegations. And the first step was to have the Office of Internal Oversight Services, which you just mentioned, OIOS of the United Nations. It's an internal body that does these investigations. First step was to have them conduct an investigation, collect all the information, interview all possible witnesses, collect any corroborating information. As best that report, their work is, as Beck said, confidential, but as best we can tell, they interviewed both the victim and Mr. Khan. They interviewed all possible corroborating witnesses, collected all possible corroborating evidence. That process took a very long time, and I think that's one of the criticisms of the process. It took much too long, but ultimately that body put together a report which didn't draw any conclusions about the evidence, but just laid it all out in its raw form. This person said this person said this email said that, and so forth. Just presented in its raw form all of the information. The second stage was you made reference to the three-judge panel that was appointed by the court to review the investigative report from the Office of Internal Oversight Services. Now, that panel was tasked to decide whether the evidence in the report satisfied the legal standard of serious misconduct beyond a reasonable doubt. But the problem was in the design, because the fact-finding and the adjudication were separated into two different bodies, the investigative body and then the judges. And so the judges really had no mechanism to resolve the disputes, the contradictions, the disputes in the facts, in the accounts, Mr. Khan's account and the victim's account. And so at the end, the three-judge panel, as you said, came to the conclusion that they could not find beyond a reasonable doubt serious misconduct because they had no way to resolve the disputed facts. The next stage was this all then went to the Bureau of the Assembly of States Parties. The Bureau is a body of I don't remember how many states, maybe 20 states.
21.
21. Yeah.
21 states. It's a body that's created in the Rome Statute, and it basically it's 21 states that gets elected for a period of, I think it's 2 years, and they essentially manage the Assembly of States Parties, which is 125 states. And the Bureau then received all this information, and they then passed their own judgment on the report and on the advice given by the three judges. And they, apparently, this has not been made public, but it's been reported that by a 2/3 majority, they concluded that Mr. Khan had engaged in serious misconduct as defined under Article 46 of the statute, and then referred it to the Assembly of States Parties for a vote, which is what occurred last Friday. So those are the stages of the process. Now, I think it's important to say that not only was this process probably ill-conceived from the beginning because the fact-finding and the adjudication were separated, making it impossible to come to any kind of conclusions. But it was also, and this is really important, it was also always clear that the opinion or whatever the three judges came to, whatever result, decision that they came to, that was always advisory. That was never going to be the conclusive opinion, decision. As Beck said, the Rome Statute entrusts this decision with the Assembly of States Parties, not with a three-judge panel. It's for the ASP to make that decision, and so it was always going to be their decision, and the judges was going to be advisory. So that gets to the first objection, and that I think is the objection we hear the most is the judges reached this conclusion, and this was ignored by the political bodies, and it was a political decision. No. First of all, I think that overstates what the judges did, what they were able to do in the process. This was not really an adjudication. This was a kind of throwing up their hands. We can't come to any conclusion here. But no matter what you think about what the judges did, it was never going to be the process that the ASP would simply defer the decision to the judges. It was their decision to make. So I think that that's with respect to the first objection. The second objection about the Karim Khan not having an opportunity to present his defense, I just don't understand that because this process went on for 20 months. By all accounts, Mr. Khan and his lawyers had every opportunity to respond to the report, to present evidence, to be interviewed, to dispute the evidence, to challenge it, and so I think that he had a full opportunity through the process to challenge and present whatever evidence was available, and I don't. There's no provision in the rules that he be allowed to present to all the states parties, and I don't understand what that would have added.
Beck, do you want to jump in with anything on the criticisms and the process?
I mean, Alex, you did a great summary there. On the latter point, I think, for those that aren't steeped in the ICC, just conceptually, it's sort of familiar from domestic practice when we think about notions of like materiality or harmless error. It is not the case that every time there's a procedural irregularity, that necessarily has a substantive impact on the outcome. And in this particular case, as Alex said, when we have Mr. Khan having been given full and complete opportunities throughout this lengthy process to present his position, it is difficult to square that with this due process claim. all of that said, I think at the same time, and it's good, Ryan, that you separated out the two criticisms. At the same time, it's very clear that the ICC was caught flat-footed. It was without an established, detailed, or workable process in place at the outset for investigating a serious allegation against its highest elected official. And that is damning of the court as an institution, and it's going to be critical going forward. It was not good, obviously, for anybody involved. Again, let me bring up the complainant in this situation and what is already massively stressful, the anxiety by the lack of clarity around the procedure. And, it took forever. The court has had this shadow hanging over it now since 2024. It's been without a chief prosecutor since March of 2025, while operating in this very hostile geopolitical environment. And all of the lack of clarity and contention around it has opened up space for claims of political interference, which is something further that we can discuss. So the ICC needs to get its own house in order going forward in terms of how it addresses workplace misconduct. I guess I would only add, because I haven't seen it elsewhere, and maybe this is not, certainly this is not specific to the court, but to the extent that the court is going to take stock, you have, as you so often have in a Me Too scenario, a alleged abuser at the height of his career with access to the best legal defense that money can buy, with social capital, with political capital. You have a complainant who is so often a subordinate, someone junior, who doesn't have those resources. Again, this is not unique to the court, but it is an ongoing structural problem to think through when looking at these kind of investigations of sexual misconduct in the workplace.
Yeah, and just to add a couple additional thoughts to that, I think even just from what you both just described and discussed, there are many lessons here. Not, as you just said, Beck, it's not unique to the court. It's for intergovernmental organizations writ large to, in advance of going through these kinds of issues, they could better adjust their procedures, the structurally, like support for complainants, and the rest of it. And I just want to flag for people to be thinking about, including the Assembly of State Parties as they move forward in revising their own procedures for handling these kinds of matters, is the beyond reasonable doubt standard. When I first encountered that, I thought, what on earth is a criminal standard for whether or not somebody is subject to imprisonment doing in these contexts at all, when it comes to senior officials in intergovernmental organizations accused of gross misconduct, let alone sexual violence, sexual abuse, or the like. And my sense is that it is the prerogative of any group of state parties to an international organization to come up with their own procedures. They don't have to go to a default as to whenever that standard should or shouldn't apply. They can create their own standards for their internal compliance and the rest of it. So just a real strange place in terms of people, as you also describe it, Beck, like just taking a step back and the power disparities here, and then all those power disparities and beyond a reasonable doubt for the alleged perpetrator. It's really, it doesn't seem to make sense, especially now day and age of understanding these kinds of issues. I do want to address what some will think of as an quote unquote, an elephant in the room. So in mentioning the fact that the court is under an enormous geopolitical stress, political pressures and things like that, some argue that the diplomatic effort to remove Mr. Khan was driven in some significant part by the United States and Israel to try to remove the prosecutor for seeking the arrest and prosecution of Benjamin Netanyahu. So the argument is, behind the scenes, Israel and the United States have been doing many things. A lot of them are being reported about opposing the court and opposing Khan for the investigation in Gaza. And the criticism is, and the idea is, that was also at play in these procedures and the decision to remove him. So I just wanted either of you or both of you to address, is that correct in your estimation that the outcome or the ultimate outcome, the ASP, the Assembly of State Parties' decisive decision to remove Mr. Khan, let's put it this way, would not have occurred without the factor that I've just described of U.S. government and Israeli government pressure?
So I'm happy to jump in on that first. I think there's just no evidence of that, and to echo some things that Beck was saying about the process. The process was broken. I think ultimately it was fair because the critical elements were complied with. Mr. Khan, the allegations were investigated. Mr. Khan had an opportunity to defend himself, many opportunities to present his defense and his account of events. And the body that was responsible for making the decision made the decision under the required statute and rules. So I think there ultimately was a fair process, but it was a mess. And as you said, Ryan, the ASP, is the Assembly of States Parties, is going to have to think about how to fix this process to make it to go more quickly, make it more streamlined, to make it make more sense, should merge together the fact-finding and the adjudication, and to communicate more clearly about it. All those things have to be done. But those failings, as Beck said, I think this is like a really, really important point that she said, is that those failings gave the opportunity for these arguments that you just made. If the procedure's not being followed, that can only be explained by political forces at work. And what are those political forces? Well, of course, it's the United States and Israel pushing back and trying and punishing the court, or more specifically, punishing Mr. Khan. But there's just simply no evidence that the ultimate outcome, that 82 states that voted in favor of removing Mr. Khan that outcome was caused by the United States and Israel. Now, of course, those countries capitalized and made hay of this and celebrated it and so forth. That's what states do, and that was to be expected, and that's part of the reason you don't get yourself into this situation, right? It's because states are going to take advantage of it. But that's a really different thing from saying that that's why the states made the decision that they did. The states, I'll say two things about this, that not only is there no evidence, but there's no reason to think that this is what caused it. Because number one, the states, in my experience, the states really do care about the workplace culture at the court. This has been a major issue for them in the selection of Mr. Khan, in the how they monitor the court. Some of the steps that they've taken, they really care about. That is a very important issue for them. And secondly, the states have been largely supportive of the court's work and letting the court be independent. And there's been no indication that the states have been out to remove Mr. Khan or remove the prosecutor before Mr. Khan for controversial decisions that they made. So I think it's a mistake to tie this event. This is, as Beck said, this is about misconduct. The states kept their eye on the ball. They focused on that, and I think that's what the decision was here.
Beck, do you want to add anything?
Yeah, I mean, really echoing that, but I just want to be clear because there's been a number of claims out there, should we say, that anyone who has been focused on the misconduct allegations has been thereby ignoring the geopolitical realities. But in truth, there is more than one thing going on here at the same time, and we have to be able to hold the complexity. It is true that we have this serious allegation of sexual workplace misconduct, and it is true that there is a campaign by Israel in relation to the Netanyahu warrant. And I would say, just like Russia in relation to the Putin warrant and the Sudanese government in relation to the Bashir warrant back at the time. It is fighting hard for impunity. It's lashing out against the court. On top of that, we have this huge campaign by the Trump administration to destroy the court entirely. And to add a further layer, we have a global South, much of which is still skeptical of a court that in its first 15 years only put African defendants in the dock. And so it's just that it is possible to acknowledge all of those geopolitical realities without saying that they must be the decisive factor in this completely separate claim of workplace sexual misconduct. And unfortunately, the concurrence of those two things, I think, helped to generate the sort of toxicity around this. And, speaking of elephants in the room, there's a couple that I think are worth naming. There was a disinformation campaign to suggest that the complainant was a puppet of the Israeli government. Absolutely no evidence to suggest that that was true. And yet she's ended up in a position of being on Christiane Amanpour, having to defend herself against exactly that allegation. The other really sort of pernicious narrative that started to creep in, and Brenda Hollis did a good job yesterday of kind of confronting this, but the idea that Karim Khan was the ICC when it came to the Israeli arrest warrants, this idea that a vote to remove him would be an end to the warrants. But in reality, he's only ever one person. He's a very important one in the court. He was, but the court is more than one man. And those arrest warrants came to fruition through the tireless work of investigators, of prosecutors. It was the three judges that actually issued the warrants. And so I think it does a great disservice to all of that work of all of those people to have kind of created this narrative around tying Mr. Khan's survival to the survival of justice for Gaza. Now, none of that is to say that Israel wouldn't have lobbied very hard for his removal, the US as well. None of it is to deny those geopolitical realities. It's just to say that based on the information that we have, the ASP has a statement on its website being very clear about that the vote was, quote, not related to the conduct of investigations or proceedings for the court.
Yeah. And I might even just, add a punctuation point to both what you said, which I always just hesitated to say anything because I think you both articulated that in such a powerful way with different points to it. But, punctuation point on it as well as the statement by the Palestine's mission to the Netherlands right after the vote. And in some sense, the way I interpret it is the statement is essentially saying the same thing of this was not a vote about the situation in Gaza. This was a situation meaning like the prosecution and investigation of the situation in Gaza. This was something separate about Mr. Khan and the allegations against him. And in some ways, I even think of that as like, having to run this rearguard action against the narrative that was being created by some that the vote to remove Mr. Khan was having to do with the assumption being like a successful campaign on the part of Israel and the United States on the issue of the Gaza criminal prosecution and investigation. And for those who support that criminal prosecution investigation, like the Palestine mission, they're actually trying to now fight against that narrative that was created in that moment. And I wonder if some people who are creating that narrative will now switch, in fact, because it has a different outcome to it. So I just wanted to do a final kind of question about what is, in some sense, more the bulk of the piece that you two wrote at Just Security, which is very forward-looking and thinking about the future of the court, since this is obviously an inflection point and now a kind of a refresh as the court moves to select a new prosecutor. And if you can both talk about that issue, which is, one, as we've described in this conversation, there is a rupture, for lack of a better word, within the international legal community of scholars and the like who have traditionally just supported the court in various ways, rupturing over the way in which the process happened. So what can repair that rupture? How should people think about overcoming that rupture? And then who are the kind of key actors in trying to build back support for the court and the work that it has to do in the future across the globe?
Beck, you want to go first?
No, I was leaving that to you.
Okay. Well, so I think, first of all, with respect to the rupture, and this is to kind of pick up on the point that you just made, Ryan, what is difficult and painful about this is this whole thing is that, I think that many, if not all, the people who have been debating this issue with Mr. Khan ultimately wish for the success of the International Criminal Court. And this infighting, you might say, is ultimately terrible for the court. And the court has enough enemies already around the world. We've mentioned, the campaign of the United States, but there are many countries that are moving away from the court, from international obligations and institutions. The court needs all the friends and support it can get. It needs people kind of working to support the court. So we have to find a way now to move beyond this and move. The vote has been taken. It was toxic. There was bitter fighting, but the vote's over. The case is over, and now we have to move forward. And I think this is one of the things that we tried to say in our piece. And now we really have to look forward, and I think it's important for people to find a way to kind of come together to think now, focus on the court and how to make the court better in specific ways with its procedures, but also succeed in the world in its critical mission. And the court, as you both have been saying, the court, and as everybody knows, it's an incredibly challenging time. I mean, the last few years, we have seen dramatic events at the court, and both that have been instigated by the court bringing arrest warrants in Ukraine, in Palestine, the case against Rodrigo Duterte, which is proceeding at the court. A lot of activity, a lot of events at the court, and then of course, the court being the focus. And I think that the states parties and the supporters of the court really now, by necessity, have to kind of take stock. A new prosecutor has to be appointed. It should be a prosecutor that's appointed for a full 9-year term. There should be a full process to do this. Find somebody who can manage the court and manage these issues. And we really have to think about the commitment of the states to the court and about who will be the best prosecutor to lead the court in these incredibly difficult times.
So, I mean, a couple of aspects of that, as we look forward to the election of the next prosecutor, historically, this has been a contentious process, has been plagued by the same problems of procedure. And so while I think it's one of those situations where the Assembly of States Parties needs to move fast in the sense that we currently have a court without a highest elected official in charge, and that is just a problem for the court. At the same time, it's going to need to be really clear in advance about what its process is. And we need to get agreement and buy-in from everybody on that process and then stick to it. So that the process of the election can be this point of coming together and supporting the court to move forward rather than another process of rupture, which is what is, certainly a legitimate risk. So it is about the ASP getting its house in order. Alex and I spoke also about internally within the court, not only investigations of workplace misconduct, but just workplace culture more generally has been a challenge for the court. From its first term, we had Fatou Bensouda starting to work on it in the second, and it has been ongoing. But what we see in this is that it needs to be led by example from the top as well. And then the external piece. At the end of the day, this court lives or dies on the decisions that states make to fund it, to share information with it, to give it access to sites of investigation, and to execute its warrants. And in this environment of extreme hostility by some states who have a vision of might makes right, or who want their officials shielded when they violate international law, it is really going to be on the many, many other states out there who do want a world that is upheld by the rule of law to hold strong in this moment. And that's difficult when you have, in particular, a state with a kind of power and leverage of the US trying to kill the court. But this is where I would make my sort of ongoing call to regular people out there. One of the ways that leaders of states that would be inclined to see the court succeed are bolstered is when they hear from their constituents and get domestic political support to stand up to the US effort to kill the court and to fight for a vision of a court that can actually succeed. And so I don't want to have people leave this conversation feeling hopeless. I think we underestimate just how much so many people around the world really care about the survival of this court. And there's a lot of work to be done, but I truly believe that we can do it.
It's a great note to end on, and also just makes me think about how politics and geopolitics are dynamic, not static. And, after Russia's invasion of Ukraine, or full invasion of Ukraine, huge bipartisan support inside the U.S. Congress for the International Criminal Court, led by surprise in some ways by Lindsey Graham, of all people, and passing legislation and the like to support the court by massive margins. In the House and the Senate. So there are ways in which the court serves global interests and can be recognized as such when there's mobilization, political mobilization, and consciousness about it, I think, too. So just want to thank you both for really an incredibly insightful conversation. I appreciate it so much, and I'm certain that our viewers and listeners do as well. And this episode was hosted by me, Ryan Goodman. It was produced by Daniel Hajnaki with help from Pooja Shah. Special thanks to both of our guests, Professors Rebecca Hamilton and Alex Whiting, for joining. You can listen to this episode wherever you get your podcasts or watch it on Just Security's YouTube channel. Additional resources for further reading, including the articles that we referenced in our conversation, are linked in today's show notes. Thanks so much for joining us.
Thank you both.